Commissorium. Is it legal or not? Our team are the following: Balan Aileen Jonel, Del Agua Athena Joan, Garcia Reynaldo, and Reyes Mark Andrew. The following are examples of Pactum Commissorium. Suppose there is a loan transaction between a debtor and a creditor, whereby the debtor put up as a security the mortgage of his property. Eventually, the debtor entered into a deed of absolute sale with the creditor, but the debt continued to subsist and the debtor remained in possession of the property. Another example is this. The wife of A pledged a set of jewelry to B for the medical expenses of his son amounting 500,000 pesos. The wife of A made an agreement that if she fails to pay B within 3 months, the ownership of the jewelry will be transferred to B. These are the reasons why people entered Pactum Commissorium: medical emergencies, chronic and debilitating diseases, protracted gambling, education, housing. The following are the examples or what kind of property they're mortgaged when they enter Pactum Commissorium: agricultural land, house and lot, jewelry, car, vehicle.
According to the cases stated below, the definition of Pactum Commissorium is a mortgage or anti-crisis by virtue of which, if the debtor cannot fulfill his obligation, the creditor can appropriate or dispose of the thing given by way of pledge, mortgage, or anti-crisis. It is a stipulation in a contract of mortgage, of pledge, which provides that the mortgagee will automatically own the property mortgage in case of the mortgager fails to pay the credit. If you buy a house, the mortgage contract cannot contain a clause that will enable the bank to sell the house without a court order in case that you default of the payments. In other words, the process whereby attachment takes place must be followed.
Article 2088 of the Civil Code prohibits the creditor from appropriating the things given by way of pledge or mortgage, or from disposing of them. Any stipulation to the contrary is null and void. Arrangements in violation of this are called Pactum Commissorium, which exists when there is a pledge or mortgage wherein property is encumbered by way of security for the payment of the principal obligation, and there is a stipulation for an automatic appropriation by the creditor of the thing in the event of non-payment of the principal obligation. The requisite of Pactum Commissorium is 1. That there should be a pledge or mortgage wherein a property is pledged or mortgaged by way of security for the payment of the principal obligation. And second, that there should be a stipulation for an automatic appropriation by the creditor of the thing pledged or mortgaged in the event of non-payment of the principal obligation within the stipulated period.
An example of the case is A. Francisco Realty and Development Corporation versus Court of Appeals and spouses Romulo S.A. Havilon and Erlinda P. Havilonar. The facts of the case are as follows. A. Francisco Realty granted 7.5 million pesos loan to spouses Havilonar, in consideration of which the latter executed A. promissory note, B. a real estate mortgage over a certain property, and C. an undated deed of sale of said mortgage property in favor of A. Francisco. Upon maturity of the loan, the spouses failed to pay. As a consequence, A. Francisco registered the sale of the mortgage property for which a new TCT was issued. A. Francisco then demanded possession of the mortgage realty. The spouses refused to vacate. A. Francisco then filed the case for possession before the RTC. The spouses admitted that their financial liability to A. Francisco, but they also alleged that it was not their intention to sell the realty, since it was merely an additional security for their loan payment. The RTC adjudged in favor of A. Francisco. On appeal, the Court of Appeals reversed RTC. holding that the deed of sale was void, being in the nature of Pactum Commissorium, which is prohibited by law. Hence, this petition with the Supreme Court. During trial, A. Francisco contended that the forfeiture clause of promissory note was not a Pactum Commissorium because under Article 2088 of the New Civil Code, provided that the Pactum Commissorium is a forfeiture clause in the deed of mortgage, and thus the forfeiture stipulation should be in the mortgage deed itself in order to be prohibited. The issue of the case: whether or not a forfeiture clause in the promissory note not incorporated in the mortgage deed is constitutive of Pactum Commissorium. The Supreme Court held yes. The stipulations in the promissory notes providing that, upon failure of the mortgagor to pay interest, ownership of the property would be automatically transferred and the deed of sale in its favor would be registered to the mortgagee, are in substance a Pactum Commissorium. The stipulations in the promissory note embody the two elements of Pactum Commissorium. One, that there should be a pledge or mortgage wherein a property is pledged or mortgage by way of security for the payment of the principal obligation. And 2, that there be a stipulation in automatic appropriation by the creditor of the thing pledged or mortgage in the event of non-payment of the principal obligation within the stipulated period. To sustain the theory of the petitioner that the forfeiture clause should be in the mortgage deed itself in order to be prohibited would be to allow a subversion of the prohibition. So the ruling is, the CA decision regarding Pactum Commissorium is affirmed.
The following are the remedies for the debtor. 1. The debtor may file an action for annulment of the agreement and execute judicial or extrajudicial foreclosure of mortgage property, and the process may satisfy the loan. And that's end of our discussion.